One, two, three. One, two, three.
Good morning. The Maryland Public Service Commission will come to order for its administrative meeting of October 12, 2022. Before we begin today with the business component of the meeting, I'd like to recognize that while we often offer unsolicited criticisms or suggestions of our public service companies and utilities, I would like to award praise and recognition when due. And today I'd like to recognize Chesapeake Utilities. They operate 3 of our gas pipelines in the state, including Chesapeake, Maryland, Sandpiper, and Elkton Gas. Chesapeake was recently awarded the prize of Best Corporate Governance in the United States by the World Finance magazine, and that was due to their corporate commitment to diversity, transparency, accountability, and a number of other factors. So for one of our smaller utilities in the state, I think that's a significant recognition, and would just like to recognize Chesapeake for that accomplishment today. So congratulations. We do have meeting minutes to approve from our last meeting 2 weeks ago on September 28th, 2022. All in favor, please say aye. The meeting minutes are approved. Good morning, Mr. Secretary.
Good morning, Mr. Chairman. There are 3 items on today's consent agenda. Items number 1 and 2 are unbundled network element loop forbearance amendments to interconnection agreements between Verizon and Dynalink Communications, Inc. and Charter FiberLink Maryland 2 LLC. Item number 3 is a request from Neighborhood Sun Benefit Corporation to cancel its electricity supplier license.
I'll turn to my colleagues for questions, beginning with Commissioner Bubar.
Thank you. I just really had a question on the Neighborhood Sun, item number 3. The company's request basically was to, I think, suspend if there was any way not to completely cancel. And the staff's recommendation is to cancel. And your recommendation is based on what's in the public utility articles. But they address suspension or revocation, and so I just wanted to get a little bit of clarity on the staff's recommendation. Thank you.
And do we have a representative from Neighborhood Sun here today? We do not. Council.
Good morning, Chairman, Commissioners. Catherine Moriarty on behalf of Staff Council. Yes, staff's recommendation is to cancel the license because under the Public Utility Article Section 7-507K3, it lists a number of reasons why we would find just cause to suspend a license, and not finding the market viable is just not one of those factors. So suspension is more of a punishment. They didn't necessarily do anything wrong. They don't have any customers. They've paid their outstanding assessments. So it would really probably be a better form for them to just cancel their license and reapply once they would like to enter the market again.
Okay. That's helpful. Anything else? Okay. I'm okay. Thank you.
Thank you, Commissioner. Any additional questions for this staff team? Seeing none, I would move that with respect to items number 1 and 2, that we approve the interconnection agreement 10 days after the 30-day comment period unless adverse comments are filed. And with respect to item number 3, that we cancel the company's license to operate as an electricity supplier in Maryland. The vote begins with Commissioner Bubar.
Aye.
Commissioner Lipton.
Aye.
Commissioner Richard.
Aye.
I vote aye. The motions are approved. Thank you.
Mr. Chairman, item number 4 on the administrative agenda consists of tariff revisions from Washington Gas Light Company.
Good morning.
Good morning, Mr. Chairman and Commissioners. Pam Coates on behalf of staff. On August 3 of this year, Washington Gas Light Company, WGL, filed a request for tariff revisions to General Service Provisions, GSP, numbers 14 and 15. GSP 14 describes the economic test to be applied to potential gas extension projects. WGL's tariff requires the company to use the most recent 12-month inflation rate to project revenues 30 years into the future. Given the current inflation rate, this calculation is projecting revenues that are beyond any reasonable expectation of actual recovery. If extensions are undertaken on this basis, when the projected revenues are not actually realized, the costs will be borne by the ratepayers. To remedy this problem, WGL is seeking to change the factor by which costs and revenues are projected. Staff worked with the company to revise the projection factor, and the parties ultimately concluded to use the 10-year inflation forecast published by the Philadelphia Federal Reserve. As this method is different from WGL's original proposal, staff has included proposed tariff language to reflect the revised methodology. This alters the economic test by replacing the current inflation rate of 8.26% with the much more modest 10-year projected rate of 2.8%. The second proposed tariff change affects GSP 15. The tariff currently stipulates that when a customer requests the relocation or alteration of a gas line, meter, or any other facility, it, quote, shall be at the expense of the customer, close quote. WGL is seeking to change this policy solely in regard to government entities in its service territory. WGL has requested to change its tariff such that for government entities, the amount collected will not be grossed up to cover taxes. Thus, the taxes would not be paid by the government entity and would instead be included in a deferred income tax asset, which would later enter into the rate base. A little history sheds light on WGL's request. Before the Tax Cuts and Jobs Act of 2017, the TCJA, payments that utilities received from government entities were not taxable to the utility. The TCJA removed this exception. Since that act took effect, the revenues from government entities are taxable, just like revenues from any other customer. WGL's proposed change would use all ratepayers to subsidize government entities in order to simulate an undoing of the TCJA modification. This change violates the principle of cost causation. It socializes the income taxes caused by government entities to all ratepayers rather than having them paid by all relevant taxpayers. Staff recommends the Commission reject the proposed tariff change. Staff recommends that the Commission accept for filing Washington Gas Light Company's proposed tariff revisions as modified by staff for General Service Provision Number 14 and direct the company to file red line and clean tariff pages with an effective date of October 12, 2022, reflecting these revisions. Staff recommends that the Commission deny Washington Gas Light's proposed change to General Service Provision Number 15. Thank you, and I'm available for questions.
Thank you, Dr. Coates. That was an excellent summary, and we appreciate the recommendations. With about 1 month on the job, you've jumped into the deep end of the pool, so thank you. We'll turn to counsel for Maryland Office of People's Counsel.
Thank you, Chairman and Commissioners. Michael Sammartino on behalf of Office of People's Counsel. OPC recommends the Commission approve the proposed revision to the inflation factor used in Washington Gas's line extension economic test as modified by staff. And we also recommend that the Commission deny Washington Gas's proposed change to its treatment of income tax owed on government entity contributions in aid of construction. Notwithstanding OPC's general concerns with current utility line extension policies, we do recognize that there is a significant issue with the current inflation factor the utility uses for estimating anticipated revenues on proposed line extensions. And we agree with staff analysis that using the survey professional forecasters would better insulate customers from the risks of inaccurate revenue projections as compared to its current tariff. As for proposal number 2, the change to income taxes, the treatment of income taxes owed on contributions in aid of construction, we fully agree with staff's conclusion that this should be denied. There's really no discernible ratepayer benefit to this proposal. Ratepayers will be paying what taxpayers currently pay and what taxpayers should pay. And regardless of whether Congress was correct in repealing the public benefit exemption, that's an issue that should not be addressed at the Commission level If Maryland state governments, municipalities, or Washington Gas dislikes that change, they should take that up with Congress and not use a commission proceeding to put customers on the hook as a workaround for a change in the federal tax code. With that, I'm happy to answer any questions that you may have.
Thank you, Mr. Sammartino. We'll turn to counsel for Washington Gas Light.
Good morning, Mr. Chairman, Commissioners. John Dodge appearing on behalf of Washington Gas. I'm joined by two colleagues today, Andrew Lawson, our Manager of Rates and Regulatory Affairs, and Spencer Nichols, our new Maryland attorney, who I hope to introduce you to a little bit later. Let me start by thanking the staff, as I always try to do, for their very cogent and complete analysis of the issues before you. They did a terrific job on their buck sheet. We are very grateful for the support of OPC and staff for their proposed tariff change regarding the calculation of inflation, and we agree with staff's tariff language. Turning to GSP 15, this is a policy determination for the Commission. We will implement the policy that you dictate. We had proposed this to reduce a little friction in the field, if you will. Some of the pushback we've seen in other jurisdictions about this gross up. We're a little more familiar with the model that we have proposed based on past experience, but I want to assure the Commission that the revenue and regulatory accounting is exactly the same whether we do or don't gross up this amount. Taxpayers and shareholders are accounted for, if you will, the same. So if you do decide to reject GSP 15, and I realize that wasn't much of a cross of gold speech, but if you do decide to reject the GSP 15 modification, we would respectfully request that you include very specific language in your letter order to that effect. I have something here that I'll read into the record, and I'm happy to send to the Executive Secretary, something along the following lines. Washington Gas's request to modify GSP 15 is denied. The Commission finds that all government customers should pay the tax gross up, and the company's GSP 15 tariff should not be amended to remove the application of a tax gross up on government projects. That would make it easier for us when we deal with relocation and such in the field, if we can point to an actual Commission letter order on point. With that, I'll stop and take any questions that you may have.
Thank you, Mr. Dodge, and if we adopt the recommendation, you make Mr. Johnston's life a little easier and get the clarity that you seek. I turn to my colleagues first to see if they have questions. Commissioner Linton.
Thank you, Mr. Chairman. Just one question. Good morning, Mr. Dodge. The Commission staff reported that at this point, no Maryland government entities have approached WGL regarding this, the issue of the gross up, GSP 15 gross up. I'm just curious to see if that's still the case.
As of this morning, yes. We do have I won't say anything in the pipeline, that's too corny, but we do have a backlog of orders that we're processing, and at any time, a government entity, a public entity, could push back on this topic. We've seen that in Virginia so far, and we're just trying to be consistent across our jurisdictions and get out ahead of the issue.
Okay. Thank you. Thank you, Mr. Chairman.
Thank you, Commissioner Linton. And just to follow up on that question, I believe it was in Mr. Sammartino's pleading that he specified that there may have been an inconsistency, but Mr. Dodge, just to be clear, no municipality or the state or the county has approached Washington Gas on this issue at this point?
No Maryland entity.
Okay.
That's correct.
Okay, thank you. I do support the recommendation of our staff here, and I would move that we accept the company's proposed tariff revisions for filing as modified by staff in its comments dated September 28, 2022 for General Services Provision number 14, and direct the company to file redline and clean tariff pages with an effective date of October 12, 2022, reflecting staff's recommendation, and deny the company's proposed update to General Service Provision number 15, consistent with the language that Mr. Dodge read into the record. The vote begins with Commissioner Bubar.
Thank you. I also would like to recognize Dr. Coates. Thank you for your first appearance. That was very helpful, and appreciate the perspective of all the parties. And I vote aye.
Commissioner Linton.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 5 is a request from New Market Solar LLC for a determination and site plan review required by PPRP Condition 19B in case number 9635.
Good morning, Chairman, Commissioners. Kenneth Albert on behalf of staff. Item 5 addresses a situation in which the Dorchester County Planning Commission has refused to address a request for site plan approval in connection with the solar project that has already been authorized by the Commission via issuance of a Certificate of Public Convenience and Necessity, a CPCN. At issue here is the August 15, 2022 filing by Newmarket that asked the Commission to determine that an August 3, 2022 order issued by the Dorchester Planning Commission satisfies the requirement in the CPCN that the project obtain Dorchester County's approval of the project site plan. This requirement is in Section 19B of the conditions proposed by PPRP, and I'll refer to it as the site plan condition. On June 5, 2020, Newmarket applied for a special exception from the Dorchester Board of Appeals, which would have indicated that its use was consistent with the land use policies. However, at a hearing on December 3, 2020, the Board of Appeals said that the fact that Dorchester County was engaged in a revision of its comprehensive plan associated with its land use policies required suspension of the board's consideration of Newmarket's request for a special exception. In its April 2022 decision that authorizes the project, the Commission noted that the conditions it was adopting as part of this authorization, number one, addressed the concerns raised by the local governments that included Dorchester County and the town of East Market, and two, adequately mitigate the project's adverse impact. Paragraph 43 of the Commission decision says the Commission is adopting, quote, a lengthy list of conditions designed to protect local interests and mitigate any possible negative impacts of the project, close quote. The site plan condition says that prior to start of construction, Newmarket, quote, shall obtain site plan approval from Dorchester County and certify to the Commission by filing a statement in the docket for case number 9635 with notice to PPRP that Newmarket has obtained such approval. And the site plan approval also involves a review of a project's soil erosion and sediment control plans, storm management plans, exterior lighting, and grading plans, which apparently are dealt with separately as part of the site plan process. Pursuant to the site plan condition, Newmarket submitted its site plan to the Planning Commission. But on August 3rd, 2022, the Planning Commission determined that, quote, it does not have the authority or discretion to approve the site plan for a use that is not permitted under the Dorchester County Zoning Code unless and until the use receives special exception approval from the Dorchester County Board of Appeals, close quote. However, the Planning Commission also said that, quote, the site plan as presented is approved since it appears to satisfy the technical requirements of the county's zoning code, conditioned on the approval of the Board of Appeals, referring to the special exception. This indicates that if Newmarket had received a special exception, the Planning Commission would approve the site plan because the Planning Commission determined that the site plan does satisfy Dorchester County's requirements. In response to staff's data request 1-1, which is attached to our comments, the Planning Commission stated that because the Dorchester Board of Appeals has not granted the special exception, quote, the Planning Commission determined that it did not have the authority or discretion to approve a site plan for a use that is not permitted under the Dorchester County Zoning Code unless and until the use receives special exception approval from the Dorchester County Board of Appeals, close quote. But significant is that in this data response, the Planning Commission reiterated that if Newmarket had received a special exception, which means that the Planning Commission would rule on the site plan, quote, the site plan appears to satisfy the technical requirements of the zoning code in connection with receiving site plan approval. In October 2021, the Dorchester County Council did adopt a revised comprehensive plan. Presumably because of this, the Planning Commission, in its August 15, 2022 reply to Newmarket's filing, recommends that Newmarket renew its request that the Board of Appeals act on Newmarket's request for a special exception. However, as noted, the Commission has issued a CPCN that authorizes Newmarket to construct the project based on the Commission's determination that the project adequately complies with Dorchester's land use policies. As a result, there is no need for Newmarket to obtain a special exception. Also, as from a practical matter, if a county can cite noncompliance with the zoning laws as justification to refuse to grant the required county authorizations for a project that the commission has authorized via CPCN, this could essentially nullify the preemptive impact of a CPCN. And that is something staff is very concerned about. It bears emphasis that Maryland will need a significant amount of new solar capacity to satisfy the renewable portfolio standard. This need for a significant amount of new capacity underscores the importance of ensuring that once the Commission has authorized a solar project, especially over the objections of a county that the project violates the county's land use policies, the county cannot rely on these same policies as a justification for blocking the project by refusing to grant the required permits. As a result, staff recommends that the Commission determine that the statement in the Planning Commission's August 3 order that the site plan, quote, appears to satisfy the technical requirements of the county zoning code, close quote, indicates that Newmarket's site plan satisfies Dorchester County site plan requirements and therefore satisfies the site plan condition in the CPCN. In an October 7, 2022 filing, PPRP cites this same statement by the Planning Commission in its August 3 order that the site plan, quote, appears to satisfy the technical requirements of the county zoning code. PPRP says that this statement, quote, appears to further support Newmarket Solar LLC's request in the instant case that the Commission determine that the site plan condition is satisfied. PPRP's position is consistent with staff's recommendation that the Commission determine that the site plan condition is satisfied. OPC filed a response, and they agree with staff that it's unreasonable for the county to require a special exception as a prerequisite for site plan approval. And they also expressed concern about the delay that would be introduced if you require these additional county approvals that are associated with land use issues. Alternatively, if the Commission determined that the Planning Commission's August 3 order does not satisfy the site plan condition, the Commission should request that the Planning Commission promptly address Newmarket's request for the site plan approval. And if the Planning Commission continues to assert that it cannot approve the site plan because of the lack of a special exception, the Commission should determine that the Planning Commission's August 3 order means that the site plan condition is satisfied. Another alternative would be for the Commission to require Newmarket to submit a filing that does demonstrate that they are in substantial conformity with Dorchester's site plan. But again, as noted, that condition kind of is irrelevant given that the Planning Commission has, at least on 2 occasions, already made that ruling for us. That concludes staff's presentation.
Thank you, Mr. Albert. Office of the Attorney General, do you wish to add anything based on Mr. Albert's comments? I think he did a likely accurate summary of your letter.
He did a very good job. Good morning, Chairman and Commissioner. Steve Tolson on behalf of PPRP. We don't have anything to add. As the letter stated, it appears that the county's filing in August supports the Newmarket's request that is limited to 19B here today. We don't have any other comments on matters that really aren't right for decision as far as permits, as far as we know. None have been requested and none have been denied.
Thank you. Office of People's Counsel, would you like to add?
Mr. Chairman, members of the Commission, Fred Hoover on behalf of the Office of People's Counsel. As was noted by staff, we filed a letter in support of Newmarket's request. The only thing I would add is that citing energy facilities is a difficult process. It was difficult when they were fossil fuel plants. It's now been extended to renewable plants. The state, decades ago, made the decision that the state should make the decision as to the proper location of energy facilities, whether they're fossil-based or renewable-based. And so the process was established where an entity who wants to build an energy facility files an application with the Public Service Commission for a CPCN, Power Plant Research Program, and staff does their analysis, makes its recommendations to the Commission. The Commission evaluates the recommendations and issues the license to build, so to speak, for these energy facilities. The counties participate in the process at their discretion, and the commission is required to consider their opinions, but the counties do not have a veto, and the county's consent is not required. The General Assembly decided that the state was the best entity in making this decision and delegated that authority to the Public Service Commission. You know, our view is that supporting this request by Dorchester County to ask Newmarket to continue to go through this local zoning process is just creating undue delay in establishing this process. And since they have the CPCN, the zoning requirements of the local county are essentially irrelevant. You know, under the Court of Appeals decision in Perennial, the CPCN trumps local zoning authority. So our view is you should grant the request by Newmarket Solar so they can proceed in getting the permits from the county and doing the various studies that they need to accommodate the process, but no more action should be taken related to zoning.
Thank you, Councilor. We'll next turn to Counsel for Dorchester County Planning Commission.
Good morning, Commissioners. My name is Christopher Drummond. I represent the Dorchester County Planning Commission. Let me begin by saying I think that staff, OPC, PPRP, and the applicant have completely missed the point of the Dorchester County Planning Commission. Let me begin by giving you an example that touches your statutory and regulatory authority. I have decided that I want to be a for-hire or provide a for-hire passenger service. And I operate out of Annapolis. And I get a business license from the clerk of the Circuit Court for Anne Arundel County. I go to the City of Annapolis Planning and Zoning and get zoning approval for my outdoor storage of my 6 15-passenger vans. I get zoning approval for a small office that I want to construct for my drivers and for passengers to assemble before we go to Thurgood Marshall BWI Airport. I go to the MVA and I get all 5 vans inspected, and they pass with flying colors. And I submit my application to the Public Service Commission for a license to operate as a for-hire passenger service. But I don't provide information regarding workman's compensation insurance or and the liability insurance information I provide is below the statutory requirements. The Commission says, well, we can't issue your license because you haven't provided workman's compensation insurance information. All my drivers are independent contractors. Well, you have to show us. You have to demonstrate that they're independent contractors and therefore not required to have workman's compensation insurance. Well, I'm not going to do that. It's none of your business. And I don't want to pay the money for the liability insurance at the statutory limits, statutory minimums, or regulatory minimums. And the Commission says, fine. Until you provide that, we can't issue the license. But the City of Annapolis has given me approval. The MVA has approved the safety of my vehicles. We don't have the authority, says the Commission, to issue your license. The City of Annapolis and the MVA can't force us to give you a license. We can only give you a license when it meets our statutory requirements. Everybody in this room would agree that the Commission has made the correct decision because it doesn't have the statutory or regulatory authority to issue that license because I have refused to provide you with the required information. And I think you would agree that you did make the right decision when you denied that license or that application. That is the point that Dorchester County is making here. The Planning Commission cannot be forced by the Public Service Commission to do something illegal. It cannot, under the zoning code of Dorchester County, approve a site plan for a use that's not permitted. And that's where everyone involved in this, except for this lone wolf crying in the wilderness, has got it wrong. The special exception requirement is not, in this circumstance, is not to undermine, or undermine's not the right word. We recognize perennial solar preempts location. Got that? What the special exception requirement involves, however, is imbuing the Planning Commission with authority to act. It does not have that authority. This situation is going to arise in a number of other counties in the immediately foreseeable future. And it will even be a starker example of what Dorchester County has raised. I mean the executive the commission, for example, has issued a CPCN to Morg Neck Road Solar in Kent County. That location is specifically prohibited under the zoning code for utility scale solar. It can't be approved by way of special exception. So when Morg Neck Road, if or when Morg Neck Road Solar presents a site plan to the Kent County Planning Commission, same problem. And in that circumstance, it cannot be sanitized as it can in Dorchester County by Newmarket Solar going to the Board of Appeals and asking for special exception approval, not in derogation of perennial solar, but to give the Planning Commission statutory and regulatory authority to act. Giving the Planning Commission the information that the Public Service Commission would insist that I provide to be a for-hire passenger carrier. Same thing. But Newmarket Solar has chosen not to proceed in that fashion. I don't represent the Board of Appeals in Dorchester County.
Are they here today?
Pardon me?
Is counsel for the Board of Appeals present today?
The Board of Appeals in Dorchester County at the moment doesn't have a counsel because the county council relieved the long-time lawyer for the Board of Appeals of his duties, and they haven't appointed a new attorney yet. I'm not going to comment, because it's not my role to do so, on whether or not the Board of Appeals should or should not have tabled Newmarket Solar's application a couple of years ago for the reason that it did. I might have encouraged the Board of Appeals to do something other than it did, but I don't represent the board. I don't know what the Board of Appeals would do if it was asked by Newmarket Solar to put the application back on its agenda.
Mr. Drummond, Newmarket Solar made the application back in June of 2020. It's going on 2.5 years. Why does Newmarket need to go back to the Board of Appeals? It's sitting before them, is it not? They tabled it. So why are you suggesting that Newmarket has to make an additional request now of the board?
To empower the Planning Commission to act on the site plan.
Can't the board do that on its own motion? Is there any need for the applicant to do a mother may I, after receiving a mixed message from the Planning Commission from Ms. Susan Webb. It seems that you're saying that it's incumbent on Newmarket at this point to pick up the phone and call the Board of Appeals.
If they want to satisfy condition 19B,
Why isn't the Board of Appeals doing this on its own? It's been
I don't know.
well, their failure to appear today does not look good on this request, and on Dorchester County, not the Planning Commission. You are a zealous advocate for the Planning Commission, but that's a really critical issue for me. And if they're not here to represent their interests today, we're missing a voice, because you've heard Mr. Hoover articulately state a few minutes ago, effectively, this whole bureaucracy at the local level, in his words, is irrelevant. The Planning Commission and seeking special exemptions, and effectively the PSC now occupies the field post perennial.
Commissioner Stanek, it doesn't. That's not what Perennial Solar said. That's not what this commission has said. It is said, Board of Appeals and this commission have said in a number of cases that location is preempted. But the details, what it looks like on the ground, so to speak, is left to local expertise. Because of that dichotomy, that is, preemption on location, but not preemption on technical requirements, that is what site plan is for. It's what sediment erosion control permits are for. It's what grading permits are for. It's what building permits are for. It's what electrical permits are for. Because of that dichotomy, this commission has referred to it as the regulatory gap. And this is the first situation in which the regulatory gap is real, not hypothetical. Newmarket Solar can solve that regulatory gap in this case. Mork Neck Road Solar may not be able to in Kent County. Another solar applicant may not be able to do it in Queen Anne's County when it proposes a solar facility outside the overlay zone in Queen Anne's County. May not be happening in Talbot County when more than 765 acres of solar is used up. I've forgotten what the standards are now in Frederick County. This case is not the only one where this problem is going to arise. Now, I have a couple more comments. Let's say that the commission approves the request from Newmarket Solar. By the way, I would note that Newmarket Solar did not ask that Condition 19 be modified. Condition 19 says, get site plan approval. The only body that can grant site plan approval is the Dorchester County Planning Commission, not the Public Service Commission. Might be in a different spot if they'd asked to modify Condition 19, but they haven't. But let's say that the commission decides that the Planning Commission's, what it thought was a helpful comment. That is, if you do what you're supposed to do, Newmarket Solar, and get this as an approved use, we won't make you come back for site plan review and approval because it looks like it satisfies our technical requirements. But you decide that that is a functional equivalent of an approval, which is really what Newmarket Solar has asked you to do. And everybody in this front row and standing over there at the lectern have supported. So now Newmarket Solar comes to the Dorchester County Department of Planning and Zoning and asks for a grading permit or sediment erosion control permit or electrical permit or building permit to the extent that one's needed. I can tell you that my advice to the department will be the same as my advice to the Planning Commission. You do not have authority to issue those permits. The Public Service Commission is not the Planning Commission. The Public Service Commission has made it very clear repeatedly that it's not in the land use business. The Public Service Commission does not have the statutory or regulatory authority to approve site plans. And therefore, you cannot rely upon the fiat from the Public Service Commission, give us your grading permit. Now, Dorchester County, neither Dorchester County or any of the other counties, nor the Public Service Commission created this conundrum. It's a problem with the Public Utilities article. This is a matter that the General Assembly needs to resolve, I think. Or, and if that resolution is that the Public Service Commission is in charge of everything, from location to what it looks like on the ground, fine. But the Public Service Commission is going to have to enforce what it looks like on the ground, because the counties will be out. The counties won't have authority to go and count trees, to require an applicant to replant dead and dying trees in the landscape buffer, which happens so far has happened with every single solar project on the Eastern Shore. Dead trees, way above normal mortality. Why? Because the promised irrigation doesn't happen. And who's enforcing that now? Who's going and counting trees? Who's going and making sure the trucks are irrigating? The counties. Who's calling the bonding companies when the applicants don't respond because of dead and dying trees? The counties. Who is enforcing silt fencing when the silt fence is either not there or it's breached and there's mud everywhere? The counties. But if the counties are out of the picture and the Public Service Commission's in charge, I hope you have enforcement folks available to make sure that what solar developers are supposed to do, they actually are doing. Because I can tell you from knowing from the practical point of view, being on the ground in these counties, they don't do it. They have to be monitored constantly. And the only way for the counties to do that is if they're issuing permits. And if they're not issuing legal permits, what authority do they have to enforce? So, that's the broad picture. That's the practical picture. And the legal picture in this case is that New Market Solar has a way to solve all the theoretical and hypothetical problems and practical problems that I have raised this morning.
Thank you.
Thank you very much.
We'll hear from counsel for New Market Solar, LLC.
Thank you, Mr. Chairman, Commissioners. David Buellmans on behalf of New Market Solar, LLC. I'm joined today by Mr. Ryan Showalter. He's the local land use attorney for the project. He was also the project's expert witness on land use and zoning issues during the CPCN proceeding before the Commission. I would like to take a moment to respond to the Planning Commission's attorney's comments this morning. As Mr. Drummond alluded to, I think this is a very important case before you today because I think at its core it will decide whether counties have the authority to veto projects that have received a valid CPCN from the Commission. Respectfully, this would be inconsistent with the Perennial Court of Appeals decision. As staff indicated, it could harm the state's ability to meet its RPS goals. The parties had a thorough discussion of the history here, but again, PPRP condition 19B requires a project to apply for site plan approval from the county, and the project did just that. In response, the Planning Commission issued a letter saying, effectively, this site plan meets our requirements, it would have been approved, but we don't have authority because there isn't a special exception. Now, a special exception is very clearly preempted by Perennial. If you look at the specific facts of that case, in that case, the Washington County zoning ordinance would have required a special exception for that project. And the Court of Appeals specifically looked at that and said that it would have been antithetical to the Commission's CPCN authority to require a special exception for that project, because then you would have the dual approval processes. Dorchester County's position here today is effectively that this is a self-created issue by the project, because the project didn't complete the special exception process. As you indicated, Commissioner or Chairman Stanek, the project did attempt to apply for a special exception. Actually, during the CPCN proceeding, the case was held in abeyance, and the project applied for a special exception. Under the county code, the Board of Appeals was supposed to act within 60 days, but it didn't. And after 330 days past that deadline had occurred, the project was forced to go back to the assigned judge in this case with a motion to adopt the schedule. And the judge agreed with that, found that the project had effectively made a good faith effort to proceed with that process to no avail, that the CPCN in the case would preempt the special exception requirement, and that it was appropriate to move forward. And eventually the commission issued a CPCN to the project. With respect to the position, the idea that the project could just go back to the county and complete the process, first off, I think history shows that that's not, there's no record to indicate the Board of Appeals would actually do that. In addition, last month of September 21st, the county council discussed an imminent solar moratorium in the county, which my understanding is it would be for 6 months. And in response to that, the Board of Appeals has informed Mr. Showalter here that it would be unable to consider any appeals of its letter. So again, I think this shows the danger in this case of giving the county further say on this matter. One final point I would like to make is the idea of a regulatory gap. And respectfully, I don't think there is a regulatory gap here. And that's because all these requirements on the project flow from the Commission's CPCN authority, which really is encompassing of everything. And that's for good reason, because if counties had site plan authority, as Mr. Drummond has advocated today, that was unchecked by the Commission, they could have a requirement like this, that a project needs to receive a special exception, it could then deny the special exception, and then the project can't be built. So I think out of necessity, if perennials have any meaning, everything flows from these conditions, and the Commission has final authority over them. So you see this in other contexts with certain conditions, for instance, requiring approval of various plans by the Power Plant Research Program. I think if you were to look at the statutes that govern PPRP, there's nothing in there about what PPRP can or cannot do, but it all flows from the conditions. The same thing is true for the site plan piece here, and the Commission has the ultimate say. I think what's important to remember in this case is the Planning Commission did review the site plan. It issued a letter saying that it complies with the requirements and would have been approved. So I think the Commission has what it needs today to move forward with confidence that this site plan is sufficient. With respect to further permits, I think that's an issue, and to a certain extent, that the project will need to address as it goes along. It's my understanding the project's applied for not site plan approval, which it's already done, but also stormwater management plan approval. It's already made that submission, and that's under review by the Public Works Department. So the plan of the project is to attempt the best it can, as it has this entire process, to comply with this condition. And if there's an issue, I think unfortunately we would maybe have to come back before you. But at this point, it's too early to say what will happen with respect to those permits. Again, this is a project that is trying to move forward. I think the record demonstrates it's made a good faith effort to do so. For the history of the project, we were simply trying to comply with this condition, and now unfortunately we have to come before you to resolve this issue. I'll end it there, but Mr. Showalter and I are here to answer any questions.
Thank you, Mr. Bugelmans. You did, I think, accurately hear Mr. Drummond a few minutes ago saying that you may have trouble in the future if the Commission grants in your favor today getting some of the permits. So his suggestion is, why don't you just go back to the Board of Appeals and obtain this special exemption, and we would not be here today. What's the company's position with respect to that? Obviously, you filed your request for a special exemption. I don't necessarily see the need to file a second one, but his suggestion was, why don't you pick up the phone and contact the Board of Appeals?
Sure. Well, there's a couple points on that. So first off, it's preempted by the Commission's CPCN as a legal matter. So I think that's one important thing to remember. Second, there's the history here. You have the fact that this is basically sat in front of the Board of Appeals for 2.5 years without a decision, significantly past the deadline by which it was supposed to make a decision. And then finally, you have this moratorium that is imminent, and it appears that at least some parts of the county are already giving it legal effect. So if the commission were to tell the project, okay, go back, pick that process back up, we would just end up back here again in front of you. So again, this is a project that wants to move forward in the immediate term, and our concern is that if we have to keep on going back to the county, we'll just go around in circles on this. I think to a certain extent that may be unavoidable, but at least with this issue, we can resolve it today.
Mr. Drummond noted that there is no counsel for the Board of Appeals, so is there anybody to speak to over there? Do you have any counterparts, or has it been a black box? If you could just state your name for the record.
Sure, thank you. Ryan Showalter for the record. It's not entirely a black box. It has been a changing of the guards. We're on the 4th planning director since that application was filed. So when the application was filed, there's a planning director in place. It was set aside or misplaced. They couldn't locate it. That was during the period of COVID, which certainly caused disruption. A new planning officer took over. The Board of Appeals closed its record in December and went into executive session to obtain legal advice. When they came out, they announced that they had made a decision in closed session that they would not act on the application until the county updated its comprehensive plan.
That was December of 2020?
That's correct. We made multiple attempts with their 3rd planning director to try to have the project scheduled for the Board of Appeals. In each instance, we're told that the board was not prepared to hear it. That planning director has since left and has been replaced. Ms. Webb, who authored the letter, is the 4th planning director during the tenure of this project. In addition, we appealed the Planning Commission's determination to the Board of Appeals. So we submitted an appeal within the last month. And the legal argument in that appeal that we intended to present to the Board of Appeals was that the special exception was preempted by perennial, and therefore the board could conclude no special exception was necessary. The Planning Commission made a legal error and had authority to approve the site plan, and therefore the project could proceed. The county council, shortly after the filing of our appeal, announced that they were adopting a 6-month moratorium. And then the Board of Appeals communicated to me that they would not schedule a hearing on my appeal of the site plan denial because of the pendency of the moratorium. The county also has they have a public hearing scheduled for October 18th on a bill number 2022-12, which would impose a maximum acreage limit for any individual project of 35 acres, 200-foot setbacks, and essentially it's an attempt to eliminate the ability to construct utility-scale solar in the county.
So you've been informed that your appeal to the Board of Appeals will not be heard anytime soon. It's being held in abeyance.
And that's the most recent appeal of the Planning Commission site plan in action.
It's frankly outrageous. Mr. Drummond, would you like to respond to that? Is that true? Is what
I would like to respond.
That his appeal is in some type of holding pattern?
First of all, the reference to a moratorium is inaccurate. There is no moratorium. There was some offhand comments about it at a county council meeting, but no moratorium has been enacted by way of ordinance or resolution.
Is one contemplated by the council?
There were some offhand comments during a council meeting. Yes,
well, what does that mean, offhand, by council members?
Yes.
Okay, that's
county council.
In a public forum.
Yeah, at their meeting.
Okay, so I would say those are on the record, not off the cuff.
Right, but there's no moratorium. I do not represent the Board of Appeals.
Well, and that, Mr. Drummond, that's the problem today. They failed to appear to matter before this state agency on something that they're directly involved in, or maybe not directly, because they haven't done anything apparently for 2.5 years.
Well-
So you're in a difficult position representing only the Planning Commission here today.
Well, I mean, I am in the sense of representing the county.
Well,
not
let's be
the
clear, Mr. Drummond. Who are you representing today? Because your letter said you're representing the Planning Commission. Are you representing the county and the Board of Appeals at
Not
large?
the Board of Appeals.
Okay.
It's an independent, apolitical, supposedly, quasi-judicial body in Dorchester County. But clearly, the county council is aware and authorized me to be here. So, you know, I'm not here at the request only of the chairman of the Planning Commission. Is the board is the Board of Appeals acting in a manner which we might wish it were not? Yes. Is there a way for New Market Solar to require the Board of Appeals to act in accordance with its own rules and regulations? Yes. Has New Market Solar done that? No. Because they're hopeful to avoid the Board of Appeals by getting the Public Service Commission to do what it wishes. And that is certainly efficient from the applicant's point of view. It avoids the frustration of further delays. I imagine that New Market Solar is playing to the urgency with which this commission wishes utility scale solar to proliferate to meet the renewable portfolio standards. But it misses the point. Just as MVA, the City of Annapolis, can't force you to do something you're not authorized by you, again, I mean the executive you, can't force the Public Service Commission to do something it doesn't have authority to do. The Public Service Commission can't force a local planning commission to do something that it doesn't have the authority to do, nor can it force a Department of Planning and Zoning to force it to issue permits it doesn't have authority to issue. That is the fundamental problem here, which will not be solved by approving New Market Solar's request. I don't know how to put it any more starkly than that.
Thank you. Let me turn to my colleagues for questions. Commissioner Buvar.
Thank you. Well, I have to say, I feel like the staff and OPC's remarks were very compelling and clear and logical, as well as New Solar, or as the company, New Market Solar. I guess I do have a question for Mr. Drummond. I'm sorry you sat back down, but you're basically saying that the company has the ability and should go back to the Board of Appeals to fix this problem. It sounds as if they have already done that, so I'm not sure what additional things you are recommending that they do. But also you noted that that this problem is something that needs to be solved by the General Assembly. So what is the company expected to do if it's a larger problem that is not really within their control to solve?
Cooperate with all interested parties, which would be the Public Service Commission, counties, towns, PPRP, staff, and whatever the appropriate committees are in the House and Senate, and come up with legislation that solves this problem while respecting the interests of the applicant, the interests of the Public Service Commission, and the interests of local jurisdictions.
So are you saying not just go to the Board of Appeals, but actually try to get legislation passed, is what you're recommending the company do?
In this circumstance, the problem can be solved. If they go to the Board of Appeals, the Board of Appeals persists in being recalcitrant. I hate to put that on the record, but I suppose that we could honestly say that the Board of Appeals is being a bit recalcitrant. If the Board of Appeals will not act, there are judicial remedies for that, mandamus perhaps. If the Board of Appeals acts and denies the special exception, they may very well have a successful appeal to the circuit court. That's all delays. I get it. It's delays. But they have a method by which they can get to a point where Dorchester County's administrative agencies can issue the permits to satisfy Condition 19. The problem that I'm describing, if they choose not to do that, will repeat itself in every other county, almost every other county in the state, in which utility-scale solar is proposed. And that's why it needs a legislative fix.
Okay. I understand that bigger picture problem, but the delays have been in existence, and so there could be further delays associated with not even making the decision. So getting the decision made clearly takes time, but it sounds as if there's indications
Well,
that
may I, again, from the practical perspective, seeing these things locally, getting approved in Baltimore, and then waiting. As a practical matter, I think of all of the very large solar projects for which CPCNs have been approved on the Eastern Shore, one is under construction. That's in Queen Anne's County. There are some projects for which CPCNs were approved upwards of 5 years ago, where there's still corn and soybean being grown in the fields. So, Mr. Bugelman's complains about delays that the counties and or towns are creating delays. In this case, that may be true. But once they get through all the hoops, nothing happens anyway for years. So I'm not so sure we should take too seriously the claims of the solar developers that it's the counties that are causing all the problems, because these farm fields stay farm fields for a long time.
Okay, thank you. I have no further questions.
Thank you, Commissioner. Mr. Drummond, I would just note that we did have a CPCN process. A lot of the parties that you mentioned, OPC, the counties, House members, Senate members, the resource agencies were all a part of that process way back when. So I don't necessarily see the need to move forward. I also don't see the extent of the problem that the county articulates here. The applicant has made clear that they've gone back to the recalcitrant Board of Appeals, and the Board of Appeals has effectively done nothing to assist this application along the way. And I recognize that it's an independent body of the county. I'm going to propose a motion that we approve the company's request that the decision letter received from the Dorchester County Planning Commission satisfies the site plan approval requirement in PPRP condition number 19B as in Bravo. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 6 consists of tariff revisions from the Delmarva Power and Light Company.
Good morning, Mr. Delgado.
Good morning, Mr. Chairman and Commissioners. Eric Delgado on behalf of staff. On September 8th, 2022, Delmarva Power and Light Company, DPL, filed revisions to its electric service tariff in compliance with Commission Order number 90298. Order 90298 authorizes expanded enrollment for DPL's pilot time of use rate offering, Schedule RTOUP, contingent on several modifications. The modifications include the addition of the 5 p.m. to 9 p.m. block to non-summer on-peak hours for both supply and distribution rates, Supply and distribution rates have been updated to incorporate the most recent cost of service study results from case number 9670. This includes updates to the billing determinants used for the on and off peak periods. The proposed changes would decrease summer on-peak distribution rates by 27.26% and decrease summer off-peak distribution rates by 2.08%. The winter off-peak rates for distribution would decrease by 38.6%, and winter off-peak distribution rates would decrease by 7.19%. The proposed changes to supply rates would decrease winter on-peak rates by 31.75% and winter off-peak rates by 0.93%. Inclusive to the changes in rates, tariff language has been updated to reflect expanded enrollment. This includes updated language regarding availability, contract terms, on-peak hours, and holidays. Our TOUP is now open to customers who wish to opt in. However, the rate offering will not be available to new net metering customers after July 26, 2022. The updated language on the tariff is consistent with pre-existing language for Schedule R on contract terms. Lastly, the applicable holidays on the tariff have been consolidated to as designated by the federal government as opposed to simply listing each applicable holiday. Staff finds DPL's revised tariff language and rates regarding Schedule RTOUP compliant with Commission Order Number 90298. Staff recommends the Commission accept for filing the proposed tariff changes with an effective date of November 1st, 2022. Thank you, and I'm available for any questions.
Thank you, Mr. Delgado. Councilor Delmarva, anything to add?
No, just thanking Mr. Delgado for his very thorough buck sheet.
Thank you. Seeing no questions, I would move that we accept the tariff revisions for filing with an effective date of November 1st, 2022. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
Commissioner Richard.
Aye.
I vote aye. The motion is approved.
Mr. Chairman, item number 7 consists of tariff revisions from Potomac Electric Power Company.
Good morning, Mr. Justy.
Good morning, Mr. Chairman and Commissioners. Anson Justy on behalf of staff. On July 26, 2022, the Commission issued Order Number 90298, directing the PC44 Rate Design Work Group on how to proceed regarding the expanding the time of use rate pilot. On September 8, 2022, Potomac Electric Power Company, PEPCO, filed tariff changes to update its Schedule RTOUP to comply with that order. PEPCO has done 6 things. It has added new language clarifying that new net metered customers are not eligible for the schedule. It has removed language indicating limited schedule availability due to its pilot nature, updated the definition for on-peak and off-peak hours, updated on-peak, off-peak, and offset distribution rates, updated on-peak and off-peak SOS rates, and changed its definition of holidays. The company has increased the number of hours defined as on-peak for the winter season such that 5 to 9 p.m. is now considered on-peak in addition to the hours between 6 and 9 a.m. as previously defined. This increase in hours affects rates in the winter. The company has also updated its cost of service data that is included in rates which affects both seasons. Summer on-peak distribution rates are expected to decrease by approximately 2%, while off-peak distribution rates are expected to increase by approximately 32%. Winter on-peak distribution rates are expected to decrease by approximately 56%, and off-peak rates are expected to decrease by approximately 35%. Winter SOS rates are expected to decrease by 29.12% during on-peak hours and by 1.43% for off-peak hours. The company has indicated it will use mail and email to communicate these changes. The company's definition for holidays is being updated to state that holidays are those determined by the federal government rather than listing each holiday in the tariff. This occurs twice in the tariffs, and the change was inadvertently not included in one of the instances. The company has indicated that it is amenable to updating both instances to have the same definition. Staff recommends the Commission accept the proposed tariff revisions, including an additional update to its holiday definition for filing with an effective date of November 1st, 2022, and that the company be directed to file clean copies of its tariff. Thank you. I'm available for questions.
Thank you. Counsel.
Nothing to add, just appreciate Mr. Justy's thorough buck sheet, and we will make that correction, Your Honor.
Thank you. Seeing no questions, I would move that we accept the tariff revisions for filing, including an additional update to the company's holiday definition as recommended by staff in its comments dated October 3rd, 2022, and direct the company to file clean copies of the revised tariff pages with an effective date of November 1st, 2022. The vote begins with Commissioner Bubar.
Aye.
Commissioner Linton.
Aye.
And Commissioner Richard.
Aye.
I vote aye. The motion is approved. Before we go on to our next item, we're just going to have a brief break, so we'll hold off on the secretary announcing that item. We'll reconvene at 11:20. If parties would like to get comfortable at the table, 1 seat per party, so the first 6 who get up here get seats. And Mr. Dodge, now might be a good time if you'd like to bring up your new hire.
Mr. Chairman, item number 8 is a status conference regarding Potomac Electric Power Company's tariff revisions pertaining to streetlights.
Thank you. When we last left off, we provided some instructions for the parties to continue to work together, asked that PEPCO convene a number of in-person meetings, and it appears that those directives were followed to the letter. So, Mr. McKeel, thank you for filing your nearly 200-page document, along with all the slides and supporting materials. We also did receive 3 other pleadings within the past 24 hours from Mr. Woodbury of Lighting Smart Energy, the City of Gaithersburg, and Section 3. So just counting heads here, we have Section 3, Delegate Carr. If you could please state your name
My
for the
name's
record.
George Woodbury with Light Smart Energy Consulting.
Thank you for, did you drive up today from North Carolina?
I changed my mind and flew up first thing this morning.
Smart man. Huh.
I'm David Costin. I'm a counselor in Washington Grove and a member of its Residents Lighting Committee.
Thank you. So you're representing the Washington Grove?
Yes.
Thank you. And you're with the Village of Chevy Chase.
Sue Ellen Ferguson here representing the Village of Chevy Chase. The village manager is also here with me, Shana Davis-Cook.
Thank you. And ma'am, if you'd like to join us, we do have one extra seat at the table here. If you could gently move the laptop if it's in your way. We have counsel for the utility with other representatives from PEPCO, and we have Mr. McGregor representing our staff, commission staff today. Mr. Michael, I don't need you to sort of go over everything that's occurred. We've reviewed your filing, the topics that were discussed at the various locations around the metropolitan area. And we've received a number of requests from, including Ms. Ferguson and yourself, that the parties could benefit from additional time. Although we also received some comments from Ms. Hardy and from others saying that there are issues that still need to be addressed. So if you'd just like to provide us with a high-level overview of where you think things stand now, and again, you don't need to go through your very comprehensive filing.
Sure. Thank you very much, Mr. Chairman, Commissioners. Doug Michael here on behalf of PEPCO. As you noted, we've held 4 meetings. I think those are the preliminary meetings. As I said in the October 10th filing, there's much work yet to do. We're committed to continue to work with the parties. We're willing to hear their feedback. Obviously, we got some of their feedback on these filings to continue to work through these issues. I think that we have provided, PEPCO has provided a lot of information out there. Model pole attachment agreement, model purchase agreements, information on fees and the like. And at this point, we're waiting to hear back with more specificity on what the municipalities want and try to come to the agreements on the items that we can agree on. And obviously, if we can't come to agreement on certain items, we may have to come back to this commission to resolve those disagreements. But it is my hope that we agree on as many things as possible, and I think that's something that will happen. There will be agreement. It just won't be on everything.
Thank you. I did not expect the parties to reach consensus after just stepping away for the past 4 or 5 weeks, although it's typically better that the parties get more of what they want if they could reach a settlement rather than to have this commission intervene. But I do get the sense some of the parties may be experiencing some frustration at this stage and saying the commission should intervene now. I'm not sure that's what all the parties at the table and in the room want. So let me turn to a number of the others that filed comments. And do we have City of Gaithersburg here today? No.
No.
They filed comments. Thank you. I know people have come from far and wide, so why don't we just go down the table and everybody could share their perspective of the state of affairs. Mrs. Ferguson, we'll start with you.
Thank you. We do appreciate that PEPCO has come to the table, arranged meetings, and did a lot of work, as you have said, putting together their concept of how the transfer would happen. It's also happening, as I understand it, in conjunction with, or at the same time as, putting together the final plan for changing over to LED lights even when Pepco owns the lights. And that is of interest to the municipalities who need to determine whether they will buy their own lights or remain with Pepco and pay the rates in that manner to get the LED lights. A number of the municipalities had looked at this because they weren't able to get LED lights and just went ahead and wanted to have another way of accomplishing that. In any event, mostly what has happened during the last 4 meetings is that we have learned what it is that is Pepco's position. It took them a while to put that together. You have seen it. And they have also noted, in summary way, that there are issues amongst the municipalities as to their proposals. And there are. And the specifics of those you're going to hear further on down the table. However, we talked at the last meeting about extending the time through the end of the year to see how many of the issues we can reach agreement on. And I had waited in marking up the 2 agreements that were provided, the models, until we ended up, we saw all of what Pepco had to present to the municipalities before taking on that task. So we weren't redoing it. And I, just from Chevy Chase Village's perspective, and I think some others, the opportunity to narrow down the issues that have to come back before this commission, and I think there will be some. There definitely will be some. At least to narrow those down, it would be time well spent, as long as it doesn't take too long. And so we thought that through the end of the year would be a reasonable period of time to have additional time to negotiate some of the points, because for the model pole attachment agreement that we received from Pepco was from Pepco's point of view, and it's not a negotiated agreement at this point. So, and both of the agreements that were provided are in that way, and we've also needed to understand the number of fees that are going to be attached to acquiring the lights, and need to look at that from our perspective too, and with assistance from expert testimony on that. So that's in summary. The municipalities did participate. We appreciate that Pepco followed your directive and provided us their view and vision of how this would occur, and think that a couple of more months would be helpful to see what issues we can resolve and what issues we have to leave for this commission to resolve.
Thank you, Ms. Ferguson. Washington Grove.
Thank you, Mr. Chairman and Commissioners. Washington Grove's interest in streetlight ownership proceeding focuses on basically 2 points. First, we were able a couple of years ago to install LED lights on most of our light fixtures. A couple of them wouldn't work, and that's resulted in a dramatic decrease in the electric bill for the town. So that was very helpful, and we appreciated Pepco's cooperation in getting that done. Our concern with this proceeding is, well, one, we want to be sure that Pepco does not then change out the fixtures in a way that our LED bulbs don't work anymore, and we have to go buy another set or do something like that. So purchase is a way of protecting that. The second reason of looking at purchase of the lights is Washington Grove is designated historic district. You can walk down our walkways, the alternate ones, there are no vehicles provided. You really can't tell you're not in the 19th century. And we want to preserve the aesthetics, and the town was greatly concerned a few years ago when a Pepco representative said, oh, you need new lights in here, it's much too dark at night, and we have to make it brighter and newer, and so on. So we have that concern. The General Assembly has compelled the sale of street lights but fixed a price at fair market value. What fair market value, by any legal definition, really doesn't apply in this situation. Fair market value requires both buyer and seller to be willing. In this case, there's a compulsive sale. It also suggests that both parties have full knowledge, and we clearly don't have full knowledge here. So those kinds of things, a General Assembly fix would certainly be useful, and we would like to see something like scheduling a net book value and restricting pole attachment fees and survey costs and so on. We appreciate all the work that PEPCO did in putting together the meetings, but the message that came through to a lot of the local municipalities, including ours, was that if you want to buy your streetlights, it's going to be very expensive. It's going to take you a long time, and in the end, your town expenses are going to go up rather than down, and that's something we need to work on. And just one of many examples in there, they suggesting that there should somehow be an attachment fee that includes lost revenue. But of course, the Washington Grove streetlights are very old. They're beyond the age of any depreciation life. And PEPCO's answer to that is, well, we look at our statewide, what they call mass numbers. So in effect, they claim nothing ever gets fully depreciated. And they're willing to discuss that issue. But then the attachment fees, they want to use the FCC model that applies to communications companies who are not electric customers in as far as the attachments are concerned, whereas streetlights are direct electric customers. We're paying for electricity on each light, and that payment, among other things, covers the cost of operating the poles. So I guess Mr. Woodbury is expert on other jurisdictions that have satisfactorily resolved these issues, and I'd like to turn to him for continue the discussion.
Thank you. And just a question: how many poles do you have in Washington Grove?
I'm sorry, it's buried in here, but it's around 120 or something like that.
Not a tremendous amount.
Small. We're a small town, 220 houses, 500 acres.
Okay. Ms. Harney, I remember you only have 50.
We want to buy 58. We have right now we have 55 lights.
Okay. All right. Thank you. Thank you, Mr. Woodbury. Thank you for joining us.
Thank you. And I've been working with Representative Carr for the last 2 years, and that's what's drawn me into Maryland, and I am here on behalf of Washington Grove. But let me back up for a minute and tell you a little bit about my background so you understand where I'm coming from. I'm a retired Army colonel, West Point graduate with a master's in construction management. I was the director of a municipal utility company for 3 years for the 6th largest city in the Commonwealth of Kentucky. And during that tenure, I reduced our demand loads by 24%, saving my clients $3.5 million a year without it ever being visible to the clients. What we did, they never saw us do. We just did it. I became the Director of Public Works in Lexington, Massachusetts, and I was faced with a budget cut. I had a $500,000 a year streetlight bill for 3,342 streetlights, and that's what prompted me to write the first legislation in the nation that allows a city or town to take over their streetlights, Mass General Law 164, Section 34A, which was passed into law by a vote with the general election in 1998. After years of negotiation, we convinced Boston Edison to sell us that system for $1. And we reduced our bill from $500,000 a year to $100,000 a year. In 2000, I became a consultant, and I've since assisted over 133 communities with acquiring their street lighting assets. I wrote the laws in Maine and Rhode Island that allow cities and towns to do what we do in Massachusetts. I've negotiated with 5 different utilities over these attachment agreements and license, the purchase and sale agreements and the conditions of the sale. I've testified in rate and tariff proceedings. And currently my son and I run a program in Rhode Island called PRISM, the Partnership for Rhode Island Streetlight Management, where we have formed a nonprofit that manages the streetlights that have been acquired by 27 communities. We currently manage 59,632 streetlights for these communities. Now, to put that in perspective, Pepco has only 66,000 streetlights. So my staff of 3 people is managing almost as many streetlights as is currently being managed by Pepco. And we've been doing this since 2014. So I have extensive experience with the ins and outs of what it takes to manage a streetlight, to put up a streetlight, to move a streetlight, to take one down. I do all the lighting design for the communities. I'm also a voting member of the American National Standards Institute for outdoor lighting. So I come to you with an enormous amount of practical, hands-on experience around this issue. And I will tell you the impression I got of the meetings that we had were not very favorable, quite frankly. I felt like I was being schooled. And I didn't feel like I was being listened to. And I heard some things that just really angered me. So let's take, for example, the issue of pole attachment fees. There is currently the other utilities, particularly the communications, cable television companies, Verizon, those who attach wires in the communication space on a telephone pole, that pay a fee for that attachment. They are for-profit companies, and each of their attachments does not result in the sale of electricity, unlike a streetlight. In the case of streetlights, every streetlight makes a contribution because it is paying both distribution and generation costs. And as you know, distribution costs are designed to recapture the cost of maintaining the distribution system. So today, every streetlight through the rates is fully covering its fair share of the cost of that pole and all of the distribution system. Now all of a sudden, because the name on the tag that says who owns that streetlight, we want to treat them differently. We want to put them into the same class as Verizon, as Spectrum, and these other companies, and we want to start charging the communities a fee to be attached to the pole. But they're also going to be paying for the distribution through the distribution rates that they pay for the electricity they consume. Now, what Pepco says is, well, yeah, but we're going to take the extra money that these towns are paying and we're going to apply it to those rates, and it'll cause everybody's distribution rates to go down. So basically, you want to take the municipalities that acquire the streetlights and have them subsidize every other ratepayer through what they're paying. Now, ask yourself from a very practical matter, how do you do this? Do you look at the street lighting class and say, okay, I'm charging this much. How many poles does Pepco have? 1 million poles? 66,000 of those have street lights on them? Okay, so now we got to figure out what portion of the distribution costs apply just to those 66,000 poles, and then we got to figure out, based on each town, we have to deduct that from what they're paying so we can justify the $2 per month or whatever their attachment fees are going to be. It's nuts, and it won't happen. I can assure you what will happen is the towns will be paying an attachment fee and they'll be paying full distribution costs. So they'll be double charged for the same thing. The second thing I said was, well, before you buy the streetlights, we need to do an audit, and we're going to charge you $50 per light to conduct that audit. Okay? Now, first I would say Pepco should have the records of what's on every pole. I don't know how familiar you are with FERC accounting. I would hope that you're very familiar with it. But when a utility company goes out and does work on a pole, they bring the work order information back, and it goes into what's called a non-unitized account. And that's assigned based on whatever the major FERC account is that work belongs to. At some point in the future, they take that non-unitized account and they go through it and they say, okay, this is how much we spent on materials, and these are the type of materials they belong in this FERC account, and this is the labor, and this is associated with this, and it goes into that account. It gets all spread out, and then you know where it belongs. Well, as a part of that, you would think they would maintain the records from those work orders, which would tell you exactly when that was done. And in fact, I know for the utilities I've worked with in New England, they do have those records. And I have finally gotten utilities to force utilities to give me those records so that I could do an independent analysis of the net book value of the asset. In New England, none of the utilities are charging a pole attachment fee. The basis for the sale is the net book value, whatever on their book, and it's based on the specific community. It's adjusted based on the age of the community. So many communities in New England buy their system for $1. In the case of my town of Lexington, we had, as I said, 3,342 streetlights. 1,600 of those were mercury vapors. Mercury vapors have not been used by the utilities since the 80s. We had 1,100 that were incandescent radio wave fixtures. These were things that were installed in the 1920s. So I think my oldest street light was dated 1929 and was still in service. So that's what, and so in fact, when you do the analysis, the town had overpaid for the depreciation of the asset by over $236,000. So in theory, the utility owed us money, but we agreed we'd buy it for $1. And that's been what's been going forward. Street lighting represents typically 1.5% of the total revenue of these utility companies. It is a minuscule part of their megawatt hour sales. And why they treat it the way they do, it must be a cash cow. It's the only thing I can figure. The other thing that's different about a street light is it serves the public good. It's there for public safety. And these communities are hosting the utilities equipment in the public way at no cost. So there's no attachment charge for that pole that's sitting in the middle of the sidewalk in town, whereas they want to charge the town an attachment fee for that pole. We had a case in Massachusetts where a community got so fed up they decided to assess a special tax for every piece of utility equipment that was in the ground or over the public way. And that's happened, as I understand it, at least one community in Maryland. That's not where we want to go, because who pays that? Every utility ratepayer. It's just, it becomes a never-ending escalation of costs, which is not where we're going. And finally, I would say that the whole purpose of a regulated monopoly is back in the early 1900s when we formed these organizations. It was the best way to get power to the common person as quickly as possible and as economically as possible. And we oversaw this monopoly to make sure they didn't take advantage of their position by establishing commissions such as yourselves. The problem that we have now is that the private sector can provide the street lighting services at substantially lower costs than the utilities are currently charging for. And it's my belief that it's time for them either to change their charges or give up and let the towns do it. The other thing is that streetlights are becoming an important asset for other smart city applications. So we're in the process, for example, of doing a pilot program down in Jamaica where we're installing cameras, air quality sensors, we're doing traffic management, we're doing parking management, and we're doing localized Wi-Fi, and it's all established by taking advantage of the street light. I don't think it works to everybody's interest if we have to rely on the utility to provide those services on top of that street light. These are things that cities and towns should be able to do on their own, and simply have to work closely with the utility so that they're properly charged for the services, the energy that they're using to support these things. But I'd be happy to answer any questions. I've been doing this for 22 years now, and quite successfully in New England. The City of Providence, for example, their bill was $4.8 million. We purchased the system for $1.26 million. We spent $8.6 million converting it to LEDs, and we completed that work for 16,000 streetlights in 7 months. And today the city's bill is $600,000 a year. They are saving $4.8 million a year, and that is typical.
Thank you, Mr. Woodbury. We'll turn to Delegate Al Carr.
Okay, thank you. Good morning, Mr. Chairman and Commissioners. For the record, Al Carr, Delegate for District 18. And the PEPCO folks worked very hard in convening the 4 meetings. I was present for those, so that's appreciated. I think it helped the municipalities begin to understand what PEPCO's position is on customer-owned streetlights. It did reveal a number of differences in the point of view of the municipalities versus the utility, and there are a good number of unanswered questions that are out there, and I think in some cases it was a missed opportunity to discuss the established practices. As Mr. Woodbury said, this is issue's been solved in New England states, also in New York State, but I think one of the biggest and best examples is in PEPCO's DC territory, where almost 40 years ago the DC government negotiated ownership of all the streetlights, and that seems to be sort of a blind spot for the utility. But it could be a model here in Maryland, and it should be. So as Sue Ellen said, there is some more work to be done to iron out these differences. The Commission might need to resolve some of the areas of disagreement. But I think it's been really great to focus on this issue. I think one of the reasons why 15 years has gone by without much progress is because streetlights are usually buried in a much larger general rate case, and there isn't the focus that's needed. And so it's great that that focus is happening now, and I think that should continue, and appreciate this opportunity to speak to you.
Thank you. I've heard a continuing theme, and we might hear a little more of that. It appears that some felt that they may have been lectured to by the utility during the 4 foundational meetings. And I think that was, based on the PowerPoint presentations I've seen, an opportunity for PEPCO to put out its marker to explain its side of the story, and it may sound like there was an opportunity to sort of ask questions and have that dialogue. I suspect that will be the next phase going forward. You know, PEPCO has set its story, put it in writing, and now it's time for some of the harder work to begin. We'll turn to Ms. Andy Leon Harvey.
I'm the village manager of Section 3 of the village of Chevy Chase, which is a very small community. We're just 1/10 of a square mile in size, and I'm speaking on behalf of our 800 residents, and I want to thank the commissioners for creating the opportunity for municipalities to meet with PEPCO to come to some sort of mutual agreement regarding municipally owned streetlights. And as you know, particularly Commissioner Linton, Section 3 began its journey with PEPCO on this subject in 2009. Sadly, we are still talking, and we've made in this last 4 weeks less progress than I'd hoped for at this point. We asked PEPCO for fiscal clarity as to what it would cost for us to convert from our HPS lights to LED. We still don't have an accurate picture of how we could get from A to Z with PEPCO to put new lights in our community and how much it would cost. Right now, PEPCO does not offer lights that many of us find appropriate to our needs. PEPCO sees us clearly in the same light as for-profit communications and cable companies, and I think you've heard that today already. Municipalities want safe and secure streets for our residents. We want proper lighting that's essential to provide that security. And we are stuck with lights that we never asked for, that we don't like, and that are obsolete in our view. Section 3 has participated in person in all the PSC mandated meetings with PEPCO so far. We've had constructive side conversations with PEPCO staff members, However, I think I speak on behalf of everyone who participated in these meetings from the municipalities when I say that these meetings have been an opportunity for PEPCO to layer cost upon cost to this process without making any significant concessions. The response to objections to the fair market value definition, the third-party pole attachment agreements, and the extensive costs outlined make municipal ownership prohibitive. And I think it's also discouraged the kind of attendance you might want to have seen today here, because these meetings have been extraordinarily discouraging in that regard. We need the Commission to step in at some point and resolve the question of fair market value in an equitable manner. We need the Commission to step in and regulate third-party attachment agreements, and we need PEPCO to stop dismissing us by saying they'll take things under advisement, we'll consider it, it's a matter of negotiation, which we heard time and again in these 4 meetings without giving any firm responses or showing any level of compromise. Following the first meeting on September 14th, where there was an audience of over 50 representatives, largely from municipal and county governments, Section 3 submitted a list of questions, a copy of which is attached. We asked for written responses. We're not still waiting, because just as I hit the send button to you all, I got responses from PEPCO on the question.
I was going to ask you that question if the responses were outstanding, and we read your letter, so.
But I would point out that the one question, which was at the top of my email, was not even addressed, and I will read you that question because it's quite short. What if we simply notify PEPCO that we want to acquire new lights, but we do not want the existing lights in our community? The law says you have to sell the existing lights to us if we notify you that we want them. What if we don't want them? The law does not require us to buy them. They're yours. You can have them back when we buy our own lights. No response on that issue. And I've asked that question at every meeting. What if we don't want your stinking lights?
Mr. Michael, did we not resolve that question via statute at the last meeting?
I thought we had discussed that, Mr. Chairman.
Okay, so Ms. Harney, I guess I didn't understand maybe the question or PEPCO's response, but under the statute, the clear letter of the statute, the municipality would take ownership of the used poles. Is that not your understanding?
No, my understanding is that the statute is written so that communities who wanted to buy the existing lights in their community, which is pretty much what Washington Grove wants to do, could buy them. I don't think they envisioned an instance where we would not want to buy the existing lights. The law says we have to notify PEPCO. It doesn't say, it says PEPCO has to sell us the lights. It doesn't say communities have to buy them. Now, it may be an error in drafting, but the law was really written so that people could acquire the lights that were there, not acquire lights that they didn't want.
New lights.
New lights, right.
Okay. I need to think about that a little bit more.
But if you read the wording of the law itself, it says we have to notify them. It doesn't say and they have to sell us lights. It doesn't say we have to buy those lights if we want other lights.
That's an issue we could look at. I know we all read closely your comments there, and you provided us with the breakdown of.
So I'm not going to read you every line item, but like Donald Rumsfeld said, there are known knowns, known unknowns, and unknown unknowns. I have the opportunity, because I'm the farthest along of any municipality in the state, because we've been working at this for a long time, to know some of the unknowns, and they're in yellow on my submission. But other people don't even know to ask those questions. And, ideally, we would like to, any municipality would like to say, okay, what do? We want new lights. Do we have Verizon acquire, do we have a selection from PEPCO that we would like? And if so, how much would it cost for us to get those lights and have PEPCO own and maintain them? And then compare that with how much would it cost us to acquire lights that we want and we maintain them, and we just pay PEPCO for the electricity generation. We don't have any ability to make that comparative judgment. Whether we're a tiny community like mine, only wants 58
No,
lights,
we understand.
or a big community.
We understand, Ms. Harney, that you're seeking more information from the utility. Although unlike Ms. Ferguson, who's asking for some additional time to work with and negotiate with the utility, it sounds like you're off to the races. Have you had it?
No,
Or?
absolutely not. I would really like to work with Pepco, and I've had wonderful side discussions with people saying, maybe we should do some more R&D on what our offerings are, and maybe there's a way to get to this, but we don't have that A to Z. I would love to work with Pepco, but I don't want to be dismissed by, we'll take it under advisement, that's a matter of negotiation, because I'm not alone in this. And we don't have the information we need. And frankly, we don't have really willing participants. They're willing because you've mandated it. They're not really eager to have anybody buy lights.
Well,
It's very
I
clear.
suspect the utility would also prefer a negotiated agreement rather than having the commission step in. But your points are on the record, Ms. Harney, and they have been made, so thank you. If we could continue, you're represented by Ms. Ferguson, is that right?
Correct.
Do you have anything to add?
Sure.
That's good.
Hi, I believe it's now, still good morning greeting
we-
to the commissioners.
Hold on, I think when you pulled the mic, we lost our signal. Just the screens, okay. Okay.
I'll just speak briefly. For the record, Shayna Davis Cook, manager of Chevy Chase Village. Just to give you a sense of perspective, we are a community of 720 homes located at the southern point of Montgomery County, directly abutting the District of Columbia. And we currently have around 240 high-pressure sodium Pepco-owned streetlights. There are another 10 to 15 LED lights that have been put in over the last 10 years through pilot programs and direct purchases that we have made. So we have currently kind of a mixture of streetlights within our jurisdiction. Certainly I defer to the comments that were made by our legal counsel, Sue Ellen Ferguson, but I just wanted to take the opportunity to thank the commission. The position and comments that you made at your August 24 meeting were very refreshing for local governments to hear your support of our efforts in reaching resolution on this issue. And it is very clear that we would not have had the opportunity for these past 4 weeks of meetings, and even for a continued dialogue with Pepco, had it not been for your very clear direction. So I just really want to stress how much we appreciate that, and thank you for taking that position. Also want to note the time and personnel commitment that Pepco did bring to the table on this, and they did structure certainly what they felt to be informational sessions about their position on things. And ultimately for local governments, what we're really looking for is fiscal certainty. That's certainly what we came into these discussions seeking, fiscal certainty, because we have an obligation as local governments to provide that to our taxpayers. But I think what these meetings have also shown is that we need fiscal fairness and to be treated as the local governments that we are, who have a direct responsibility for the public's safety and well-being, and to not be viewed and treated on an equivalent stance as commercial for-profit companies such as communications and cable companies. And so for any type of attachment agreement or process to be premised on the same process that Pepco undergoes with for-profit companies, we certainly believe to be a disconnect in what we're trying to accomplish through our purchase and or ownership of the streetlight networks within our community. So just wanted to stress that. Again, Chevy Chase Village's position is that additional time is needed for further conversation with Pepco. But we do believe that there is an opportunity for agreement on a lot of the points related to this matter. So thank you again for your time.
Thank you for your testimony. We'll turn to Commission Staff Counsel.
Thank you, Mr. Chairman, Commissioners. James Greger on behalf of staff. While staff did not file any comments for this status conference, we did participate in all 4 meetings that were hosted by the company. I would like to echo a lot of the other commenters and thanking both the company as well as the municipalities for their participation in this or in these discussions. We would also like to echo the support for additional time in conducting further discussions. I think the last 45 days, the company has laid down a good groundwork as far as laying out the universe of possible issues that may be at play for the sale of streetlights. I think we can build on that foundation to at least reach consensus on a number of issues before moving back to the commission for any unresolved matters. Pending that, any questions? Thank you, Mr. Chairman, Commissioners.
Thank you, Mr. Greger. I'll return to Mike Keel and then open up any questions for my colleagues. Mr. Mike Keel, would you like to respond to any of the testimony you've heard today?
Sure. Just a little bit, and let me just start out with, we're open to negotiating all of this. We were tasked with providing information about what our views were, what our positions are. This is a dialogue. It's not meant to dictate to the municipalities. And I think we're happy to continue to meet with them, and I think we're going to reach agreement on certain issues. Maybe there are some that we're not going to be able to reach. I want to make a few comments with respect to, and I don't want to get into argument here because I don't think it's necessary, but Mr. Woodbury certainly is an expert in this field, and recognizing that and hearing from Delegate Alfred Carr and Mr. Woodbury that we should look to New England for guidance. The streetlight pole attachment agreement that we provided and the ownership agreement that we provided are modeled after the pole attachment ownership agreement that was approved in a Rhode Island proceeding for National Grid, where Mr. Woodbury was indeed a witness in that matter. I do take some issue with the claim that there are no pole attachment fees, and there are no pole attachment fees in New England. I mean, I don't know how else to say it, but...
And if this becomes a litigated proceeding, you could put that on the record if there are.
I understand, but I just want to say Green Mountain Power has them, NYSEG has them, Niagara Mohawk in New York has them, and I haven't done an exhaustive viewpoint, and I'm not suggesting that that's at the end of the day where we're going to get. I'm just here to say, you know what I mean, we're not the complete outlier on that. I would like to turn it over to Lance Schaefer to respond to just a couple of other issues that are a little bit more technical that I just want to make sure the record's clear here. And again, we're willing to negotiate with the municipalities and continue the dialogue and try to resolve this.
And when we come back early next year in the winter to discuss this, it would be ideal if the parties could settle or come to agreement on as many items as possible. But it need not necessarily be a global settlement with all of the municipalities. If to the extent that some of the municipalities are willing to get on board and others not, we'll carve out those and then we'll take the others to a trial type hearing or whatnot.
And just so you know, and Mr. Woodbury can back me up on this, that's what happened in the National Grid Rhode Island matter. There were some matters that they settled through technical conferences, and then some matters that they couldn't come to agreement on, and it had to come to the commission for resolution, and that's what happened. And I think we're following that path here. And like I said, I'd prefer to settle everything and agree on everything. It's easier. It makes everybody happy. It makes your jobs easier. I don't know that we can do that.
Let's hear from Mr. Schaefer. Good morning.
Good morning, Mr. Chairman and Commissioners. Good afternoon, actually, I should have said. Sorry. My name is Lance Schaefer. I'm a manager of rate administration at PEPCO. I just feel compelled to address one item. It was an important item in the meetings, and I dedicated a bit of time to it in that fourth meeting. Our customers are not double charged for attachment fees. They really are not. I showed before that when we receive this revenue that comes in through an attachment fee, it is indeed allocated back to the rate classes who are paying for the distribution system, because as people who are paying for the distribution system, they deserve that revenue. And so in the same way that, when I file a class cost of service study before the commission, I show that allocation of that revenue, and I show that it gets counted as revenue to the rate classes. Anything that we picked up in the future from a pole attachment fee would also be allocated in the same way. It's definitely not a fee that is somehow added on top of the existing expense to own, operate, and maintain these poles. This is revenue that the company absolutely does not keep. This is not profit for the company. A related item that Mr. Woodbury mentioned was the telecommunications attachments. We have telecommunication attachments that are electrified. They're paying a pole attachment fee, and again, that revenue goes back and is allocated back to the existing customers. So, I just wanted to clear that up. It's important that I say that there is not double charging of the customers, and I wanted to make sure that our customers know that. Thank you.
Thank you. And if there is a dispute regarding that, again, we could take that up in the future, but thank you, Mr. Schaefer. Anything else, Mr. Mike Hill?
No, appreciate the commission's time on this and direction, and we look forward to continuing to work in a productive manner with the municipalities.
Thank you. I turn to my colleagues. Commissioner Bubar.
I don't have any questions. I just want to thank everybody. I know these processes are very time-consuming and challenging. I actually really appreciate hearing all this. I live 2 miles from Washington Grove. In fact, my neighbors are moving there. I'm very upset because they're great neighbors. I go to your post office all the time.
We'll welcome them.
So, but I have confidence that these issues will be resolved, and if not, then they will come to the commission and we will deal with them. But thank you, everybody, for being committed to the process.
Commissioner Linton.
Thank you, Mr. Chairman. So, unlike Commissioner Bubar, I'm not as familiar with the area. I am familiar with the matter, though, unfortunately. But I am glad to see that it's continuing to move forward, and hopefully a resolution that, in terms of just a general standard for how these matters can be resolved, will ultimately be established. Because I note that at some point it's going to be discussions between utility and individual towns, local governments, etc., because each of the terms you may settle on might be a little different. So hopefully we can deal with some of these global issues so that there will at least be a standard for going forward from there. And that's what I'd like to see going forward so at some point in my career. So, thank you, Mr. Chairman.
Commissioner Richard.
Thank you, Mr. Chairman, and I just want to echo my colleagues that I do appreciate the company and the parties getting together and having this first round. I do see at this point, it sounds like the utility, Pepco, is primarily just provided information. I do hope and expect that this will now lead to dialogue and the opportunity for the parties to get to where they want to go. My read is that the legislature wants to give municipalities, communities the opportunity to look beyond their distribution utility for these services, and so I think that there needs to be a clear transition plan, and I think I'm hearing that that's what is wanted at this point. And I'm hoping that when you come back, that there will be a roadmap, a transition plan for these communities. And I'm also hearing from Mr. Woodbury that this has been done before. This has happened in many other places, and so if these costs and some of the concerns that I'm hearing from the municipalities are, that why is it costing so much more here than other places, I will really want to know an answer to that as well, because again, I think it's clear what our policy is intended to be for these communities, and it's been done elsewhere. And so I would want to know and expect it to be consistent with how it's being done elsewhere. So anyway, that's all I have to offer at this point, and I'll keep my fingers crossed that this will be a very successful, I guess we're calling it a status conference, I guess, early next year, and that we'll have a lot of happy faces sitting at this table. So thank you, Mr. Chairman.
I'm confident that we will reach a resolution. I'm not sure all the faces will be entirely happy, but we will reach a resolution.
I want smiles.
We have a number of experts in public street lighting issues here today. The utility obviously has the right people, and to the extent we don't have a full settlement, and it will be hard because a lot of these issues have a lot of price tags involved, and some of them are relatively costly. But now that the utility has laid the foundation as to sort of its understanding going forward, now's the time for the heavy negotiations and discussions to begin. So I will propose, if the parties' calendars are amenable, we'll come back on January 25th. Does anybody have an objection to that date?
is
It's a Wednesday.
I hardly know what I'm doing tomorrow,
Okay.
Mr. Chairman, but that's fine for us.
Why don't we set the marker out there? I don't see any objections being raised, and that should be sufficient time. If the parties need an extension or movement of the date, Mr. Michaela, if you could send a letter on behalf of the parties. Ms. Harney?
I have a general sort of question for the commission. Pepco has made it clear that in the first quarter of 2023, they're going to come back to you with a tariff for LED. And some of the costs and assumptions that will be embraced in that will be obviously of interest to people who may want to have Pepco own and maintain LED lights. But it also goes to, well, what will be in that tariff that relates to municipally owned street lights. And, you know, I'm worried
That's a related.
part of the picture in January.
Well, that could be discussed. It's related, but it would be a separately docketed proceeding.
Okay. I have no idea. So.
If Section 3 wishes to participate in that, Mr. Michaela could give you some advice. If the topic arises during the course of the next 3 months through discussions, as it may, then it should be discussed there. All right, so we'll bring this matter back, hopefully, for more of a settlement conference than a status conference on Wednesday, January 25th, 2023.